Hi, I'm Jason Sullivan of Rathbone Group, and in this video we're going to discuss Missouri subrogation claims. If you've ever handled a Missouri subrogation claim, you may have come across some of the nuances that make it a lot different than other states. Fundamentally, one of the big issues is that litigation had to be filed in the name of the insured. An insurance company that paid for a claim, unlike a lot of other states, couldn't just file suit in the name of insurance company versus defendant. Rather, they had to file the suit in the name of the insured, which required the insured to be on board with pursuing that litigation. The real issue with this is claim splitting. Courts don't want different parties to bring the same cause of action against the same defendants. It's not convenient or efficient for the judicial system, and it does present the risk for a defendant that they have two different judgments from two different plaintiffs for the same loss. So Missouri had a pretty conservative and traditional rule that suit needed to be filed in the name of the insured. If you've ever filed in arbitration forums, you may have seen over the last 4 or 5 years where other parties claim that unless there was an assignment of the claim from the insured to the insurance company, that there was no basis for subrogation. And during this time period, I've seen hundreds of rulings that held the claim out of jurisdiction for purposes of arbitration forums. The ruling was that the insurance company had no subrogation right unless there was an assignment from the insured to the insurance company. Now, this defense was pretty easy to overcome. You just had to reach out to the insured, get that assignment, allowing you to pursue the claim, and then the insurance company could file an arbitration, and predictably they would win and get paid the full amount. But the defense that was being raised slowed the process down, added extra hurdles, and made it more difficult to proceed. So if you have or are frustrated by this process, I've got some great news for you. In Missouri, they did pass a law in 2026 that has changed everything in terms of the real party of interest. And specifically, that statute is Missouri Statute 379.135. And the first paragraph in that section states, upon payment by an insurer of all or any part of a claimant's property damage claim, legal title to that portion of the claim paid shall vest in the insurer to the extent of such payment. No assignment or other action by claimant shall be required for the insurer to enforce its legal title. So right there, that changes the game completely. No longer is Missouri, as of August 28, 2026, a state that says only the insured can be the real party in interest, and a subrogated carrier that paid for the claim has no right to pursue the claim in its own name. Now, this statute overrides that common law and traditional rule and states that once an insurer pays the claim, they are the real party in interest, they have legal right to the amount that they paid, and they can pursue the claim in their own name. This should make things a lot easier if you're filing in arbitration forums or against a carrier or party that's not a member of arbitration, because now the suit can be filed in the name of the insurance company and you don't have to get the insured on board. That could get extra complicated when the insured had their own injury claim that they were pursuing separately, and because all claims needed to be brought at once, it would create a problem for them if the property damage was pursued separately first. So this law change and this new statute is going to be a lot more efficient, and we hope that arbitration forums recognizes this rule change pretty quickly. And you should, if you start to file claims in arbitration forums without an assignment from the insured, this statute should be something you attach to show that you no longer need that in the state of Missouri. So with this good news and this rule change in 2026, this is Jason Sullivan for On Subrogation, and that's the long and short of it.